Dear students, in this video we are going to discuss about Judiciary in United Kingdom. The present day organization of the English courts is relatively modern. Though the courts themselves are much older, they were entirely reconstituted by the Judicature Acts of 1873 to 1876 as amended by the Act of 1925. Prior to 1873, the judicial organization of England was in a scale of chaos with numerous courts possessing special functions. The Acts of 1873 systematized and recognized the courts and simplified the judicial procedure. First, we are going to see about salient features of British judicial system. The judiciary occupies an important place in the actual administration of England. English justice has been the pride of Englishmen for centuries together. This is all due to the various qualities and outstanding features which the British judiciary possesses today. The first feature of British judicial system is rule of law. There is a rule of England, and until the individual remains within the limits set by law, his rights and liberties are safe. Law is the highest power of land. No one is above law. Law is the source of the government authorities, and they also cannot do anything against law. Second feature is absence of single judicial system. There is no single form of judicial system that prevails throughout the entire United Kingdom. There is one arrangement of courts for England and Wales, another for Scotland, and still another for Northern Ireland. The law of Scotland differs both in principle and procedure, and accordingly the organization of courts is also different. The judicial system of Northern Ireland also is unlike the English system. Next feature is lack of administrative courts. There is no separate set of administrative courts in England. In England, there is a rule of law which implies absence of administrative law. The English common law recognizes no distinction between the acts of government officials and ordinary citizens. All are amenable to the same ordinary courts and to the same law, though the system of administrative adjudication is inevitably developing. Then, absence of judicial review. In England, there is no system of judicial review. No act of the Parliament can be declared ultra vires by any court of law. Parliament is supreme, and the courts have to apply whatever law has been made by it. They have no authority to examine its validity. In short, like the United States, there is no court in England which can sit upon the Parliament and examine the validity of its laws. Next feature is high quality of justice. England can be proud of the high quality of justice dispensed by her courts. The British courts operate under salutary principles and follow simple procedure. Cases move far more rapidly in British than in American or Indian courts. Cases are heard and decided with fairness and speed. The calendars of the courts do not become closed. The judges are in general of a high order ability, independence and integrity. They are appointed for life, and removal can be made only on joint address of both the Houses of Parliament. The salaries of the judges are attractive. Further, dignity and distinction are conferred upon them. All this helps secure and retain brain, character and energy, and is largely responsible for the favorable reputation which the British courts enjoy both at home and abroad. The last feature is guardian of human liberties. As we have seen earlier in England, the liberties of citizens are guaranteed not by any parliamentary statute but by the common law of land. The civil rights, for example, freedom of speech, freedom of press, freedom of worship, etc., guaranteed by the usages and traditions are enforced by the courts. These usages are in reality more effective than any written constitutional guarantees. Kinds of laws in practice in England. There are three kinds of laws in practice in England. First one, common laws. Common laws have originated from old customs and traditions, and thus they are older than parliamentary laws. Then statutory laws. These are the laws which are passed by Parliament with due process. These are written and more authoritative. The last one, law of equity. Judges decide cases with equity, and those principles which are taken into consideration while administering justice are called law of equity. This is the structure of judiciary in UK. The present day organization of law courts in England flows from the Judicial Acts of 1872 as amended by the Act of 1925. There are two kinds of courts, criminal and civil courts. First, we are going to discuss about civil courts. County courts. The county courts are the lowest courts in civil matters which decide disputes in which the amount involved is not more than £400 sterling. There are about 500 county courts in England and Wales. They function in 75 circuits and justice is administered in them by county judges who are appointed by the Lord Chancellor from among the barristers of at least 7 years standing. The procedure in a county court is simple. Many cases are decided out of court. In every place where a county court sits, there is an official known as the registrar who disposes of the great majority of the cases by influencing withdrawals or affecting compromises without even referring them to the judge at all. A case involving not more than £30 sterling may be settled by the registrar of the county court. The next tier above the county court is the Supreme Court of Judicature. It is divided into two branches. The High Court of Justice and Court of Appeal. The High Court of Justice has three divisions: the Queen's Bench Division, the Chancery Division, and the Probate, Divorce and Admiralty Division. In each of these three divisions, judgment is administered by a bench of judges, sometimes singly, sometimes in trios. The Queen's Bench is presided over by the Lord Chief Justice of England and consists of 17 other judges. It hears common law cases and handles majority of the cases coming to the High Court, that is election petitions, applications for the writs of habeas corpus, debts and damages of unlimited amount. The Chancery Division is presided over by the Lord High Chancellor and is served by 8 other judges. It hears the cases which formerly belonged to the courts of equity. In other words, it deals with such cases in which the remedy or law is inadequate. Cases under company law, appeals in income tax cases, bankruptcies, and execution of trusts for deceased persons come to it. The Probate, Divorce and Admiralty Division is presided over a president and is served by 10 other judges. They hear particular types of cases as the name itself shows. It is said this division deals with wills, wives and wrecks. Any of the judges mentioned above may sit in any division and all may apply the common law or equity in spite of their usual specialization. Then the Court of Appeal. The Court of Appeal receives appeals from both the county courts and the three divisions of the High Court. Appeals can be taken only on question of law. There is no question of fact, though an application may be made to the Court of Appeal to order a new trial. The Court of Appeal is an appellate court which receives appeals both from the county courts and the High Court of Judges. In the Court of Appeal, no witnesses are heard and there is no jury. The Court of Appeal sits in London. It may be noted that the High Court has both original and appellate jurisdiction. On its original side, it has jurisdiction in cases in which the amount involved is sufficiently large. On its appellate side, it entertains appeals from the county courts. Then the Supreme Court. We will see about the Supreme Court lastly. Now we move to criminal courts. The lowest rung of criminal court is the Justices of the Peace. In England, when a person is charged with a crime, he is brought before one or more Justices of the Peace, or in the large towns before a stipendiary magistrate. The stipendiary magistrates receive regular salaries and are appointed by the Home Secretary in the name of the Crown from among the barristers of 7 years' standing. The Justices of Peace are honorary and are appointed by the Lord Chancellor. They have no legal training and are laymen taken from all social classes and professions. The magistrates have jurisdiction over the same classes of cases as Justices of the Peace. Then Court of Quarter Sessions. Before that, the petty sessional courts. The jurisdiction of the Justices of the Peace and magistrates extends over minor misdemeanors which are punishable by a fine up to £9 and simple imprisonment of not more than 14 days. More serious cases are tried by a court called the Court of Summary Jurisdiction, consisting of 2 Justices of the Peace or stipendiary magistrates. In the former, it is known as the Court of Petty Sessions. This court can impose a fine of not more than £100 or, in certain specified cases, £500 or a sentence of imprisonment up to 6 months and, in certain cases, a year. The accused can demand a trial by jury if the offence is punishable by imprisonment for more than 3 months. These courts function without jury. Now, Court of Quarter Sessions. Appeals from the lower courts may be taken in the Court of Quarter Sessions, which consists of all the Justices of the Peace in the country, meeting 4 times in a year, and it is for this reason that it is called Quarter Sessions. This court meets 4 times a year. This is the reason that it is called Quarter Sessions Court. It also exercises original jurisdiction in serious criminal cases, but not serious enough to warrant holding the accused for the assizes. Serious cases like those of murder, treason, etc. do not originate in this court. Appeals are ordinarily taken to the Court of Criminal Appeals. This is in fact the court in which the majority of other grave crimes are tried. Next one is Court of Assizes. In the hierarchy above the Justices of the Peace are the Assizes courts. They are branches of the High Court of Justice. They are held in the county towns and in certain cities 3 times a year. Each such court is presided by a judge or sometimes 2 judges of the High Court of Justice who go around on circuits. The Court of Assizes functioning in London is called Central Criminal Court. The jurisdiction of the assizes includes all the grave offences, for example, armed robbery, kidnapping, murder. The assizes court is assisted by a jury of 12 countrymen. The Court of Criminal Appeal was set up by an Act of 1907 to hear appeals from the verdict of a jury in a criminal trial. Formerly, no such appeal could be preferred, but now a convicted person may, as a matter of right, appeal to the Court of Criminal Appeal. Now we move to Supreme Court. The inauguration of the Supreme Court was on October 1st, 2009, and it was situated on the corner of Parliament Square in the Middlesex Guildhall, and judicial powers being exercised by House of Lords have been passed on into the hands of Supreme Court. Regarding composition of the Supreme Court, according to the Constitutional Reform Act 2005, including President and Deputy President, it is made of the 12 judges of the Supreme Court, and 12 law lords have to be appointed the first judges of the Supreme Court. Regarding appointment of judges, the judges of the Supreme Court shall be appointed by the King or Queen on the recommendation of the Judicial Appointment Commission. Regarding qualification of judges, it is written in the Constitutional Reform Act 2005 that the judges shall be appointed on merit, and the Judicial Appointment Commission shall ensure that the judges have the knowledge of law prevalent in various parts of United Kingdom. Tenure is not fixed. Regarding provision of the appointment of the acting judges, if need arises, the courts, those in Scotland and Ireland, to act as an acting judge of the Supreme Court. Bench system is prevailing there. The Supreme Court shall hear appeals through benches consisting of at least 3 judges, of which at least half of the judges shall be present. Thank you.